Okay, so the meeting is now starting. So thank you everybody for being here. Welcome and Happy New Year. The first thing we have is we have a number of regrets with respect to the roll call. I'm still admitting people to the meeting, so as we start up. Okay, so we have regrets from some fairly recent ones, as in this morning. Gil and Peter, Howard, Lynn, John and Sean have all sent their regrets, against some of them fairly recently. So we won't have their presence here today, but of course they're open and all of them indicated they're going to watch the video after its completion. So that's fine. Okay, so the first matter of business is the approval of the agenda. So I circulated that to everybody last week. So can I have a mover to do that? Okay, Andrea, and a seconder. Rob, thank you. Or Stefan. Okay, so all in favor? Okay, so the agenda is as it's been presented. Next, we have the approval of the minutes that Peter prepared for us, dated our last meeting, which is the 14th of December. So can I have a mover for the approval of the minutes of the last meeting? Matthew, a seconder. Stefan again, thank you very much. Okay, and can I have the vote on the minutes? All in favor? Wonderful, thank you very much. Okay, so let's move to the news and announcements. Firstly, we have the issue of the mandate letters. They've now finally been issued by the Prime Minister's office, and we've circulated those to you. So I can go through them. Hopefully you've all seen them and gone through them yourselves. I'll just highlight some of the issues that are in the mandate letters that we will cover for the most part during the course of our meeting in any event. Some of the mandates have in fact already been incorporated into bills that are before the current Parliament. So let's take it from here. So I'm not going to touch on every one of the issues in the mandate letters, but I'll highlight the ones that I think are relevant for our purposes. So firstly, I'll deal with the mandate letter to Minister Lametti, who is the Minister of Justice and the AG of Canada. So going through the issues in that letter, we have the first direction to fully implement the UN Declaration on the Rights of Indigenous Peoples. That's been on the agenda for the Ministry of Justice for quite some time now, and so obviously now it's just being repeated as a continuing mandate. We have the appointment of a special interlocutor for the advancement of justice regarding unmarked graves. Everybody's familiar with that issue, those that are now being found and to be found on the sites of former residential schools. Okay, so that's now been incorporated into the minister's mandate to ensure that Canadian justice policy protects the dignity and equality of LGBTQ2 Canadians, to continue working to ensure that the bench, and this would be federal appointments, obviously, is gender balanced, as well as encouraging women, Black and racialized Canadians to join the bench. It's an appointment process, but clearly there's a direction for that. To address systemic discrimination and overrepresentation of Black and racialized Canadians and Indigenous peoples in the criminal justice system. We all know what that deals with to a great degree with respect to overrepresentation in custody, both federally and provincially and territorially. There's certainly an overrepresentation of Indigenous and racialized Canadians in the custodial services. So that's something to be addressed. As part of that mandate, there is a direction for a swift passage of Bill C5, which we have in our agenda, to reduce reliance on mandatory minimum penalties as they're directed towards Indigenous and racialized Canadians. There's to be continued work to make drug treatment courts the default option for first-time non-violent offenders. So it's a specialized court. That's a relatively recent phenomenon, but it's one that's growing. Likewise, greater access to mental health courts, to establish, and this is obviously part of our agenda, to establish an independent criminal case review commission. So we'll talk about that separately because that's well on its way. To develop and introduce legislation as soon as possible to combat serious forms of harmful online content. To advance the priorities of Indigenous communities to reclaim jurisdiction over the administration of justice. All right. Oh, Kyle has a hand. Kyle, you have something to say in the chat?
Sorry, Miles. I wasn't meaning to interrupt you. I was just trying to make a link with your comment around federally appointed, or excuse me, judges and representation on the bench. There was a release yesterday from StatsCan on the gender distribution of federally appointed judges. So just trying to do the small knowledge dump in terms of recent work or releases linked to that commitment that you were describing. So apologies to interrupt.
No, excellent. No, Kyle, listen, appreciate it very much. Thank you. And yeah, and again, anybody, please jump in as I go through these issues of the mandates. If you have something to add to it, and likewise what Kyle was saying, which actually gives us a resource, please feel free to interrupt. Okay, going forward, there's the mandate to strengthen Canadian police and prosecutors to bring justice to cyber criminals and terror suspects. A mandate to help end gun violence. All of these, of course, obviously have, a lot of underlying, issues that have to be addressed to bring them into fruition. There's a mandate to revive the Law Commission of Canada. That's promising. That had, and Matthew, you probably remember this as well as I do. I think the Law Commission was killed by Harper really early in his mandate. I think we're talking the 2006, 2007 when Harper first took office. I believe he killed the mandate. Kyle, your hands up.
Yeah, just for those who are public servants on the call, there's an internal call for a director to run the comms and research shop. It closes on Monday.
Okay, thank you. Okay, there's the mandate to strengthen Canada's approach to elder abuse, to support the development of specialized sexual violence courts, which obviously would augment the mental health courts, to strengthen the laws and investigative powers related to major financial crimes, to secure support for the swift passage of reforms to the judicial conduct process. That's a separate bill already before Parliament. We'll discuss that. So those are the mandates that I picked out as I think being particularly relevant for our purposes. Anybody read the mandate letters and come up with any other issues you want to discuss?
There's one thing that I saw in the mandate letter, and I apologize if you did already mention it, but there's an entry about enhancing access to justice by bringing our courts into the 21st century. Speaking about use of technology and virtual court services. That it's close to my work personally. Like I actually specifically have an article submitted for publication on access to justice and the use of technology. I think that's something that could be interesting to follow for the CCJC, but CCJA, sorry. Yeah, that I just wanted to flag that.
No, yeah, thanks, Brendan. You're actually right. That is one of the mandates in the letter. I just didn't cover it off, but it's an important one. So thank you for bringing that to our attention. Any other particular issues in the mandate letters that you think we should explore, or at least bring to the meeting?
Miles, I was interested way back when, in the 1990s. Our association had pushed the Solicitor General, to pursue alternatives to incarceration. And we had made that a policy goal, not only of the Policy Review Committee, but of the board. And that issue has seemed to have been set aside, except with respect to First Nations and people of color. But I'm still wondering why an organization that historically was formed around community corrections, that's the history of this organization, has let that go.
Well, I mean, we're open, to discussions, along that line. We're certainly open to putting issues like that on our active agenda. So I have absolutely no problem in doing that. If you're suggesting, Matthew, that when we get to the items of interest that are new to the PRC, it's not new, obviously. It's, as you're mentioning, it's 25 odd years in the making for the PRC. But if you want to return that to our active agenda, that's perfectly fine.
Actually, Miles, I was thinking of the association potentially issuing letters to both the Minister of Justice and the Minister of Public Safety, suggesting very strongly that alternatives to incarceration be considered under their mandate. I'm just throwing that out.
Well, I would think, and again, I'm relatively new at running this show, but if that's something that you wanted to put forward, then I think you should put it forward. I think that you may want to craft what you would see as being important elements of those letters, bring it to the PRC, and then we'll discuss it, and then it would go to the CCGA board, I would think, for its consideration in then advancing it to the Minister of Public Safety and the Minister of Justice. Is that a process that makes sense to anybody or everybody?
Yeah. I mean, I think, pardon me, no, sorry, Miles. I think Matthew would have to put some meat on it, right? I mean, we can't just make a statement. We'd like to see alternatives. I mean, you'd have to develop, you have to redevelop, I guess, a position with some background, historical stuff and policy stuff. And I think we should consider it PRC. I think it's a great idea.
So I have a couple of comments, if I can.
Sure.
So in terms of alternatives to prisons, I don't know when it was enacted, but Section 717 of the Criminal Code talks about alternative measures, diversion programs. Then you have also the specialized courts. For example, the Drug Treatment Court was set up in 1998. The first one in Canada was in Toronto, another all over the country. So that's federal. In terms of provincial stuff, perhaps the feds can look at that. The last couple of years, there are 4, they're called justice centers, have been set up. These are basically, each justice center is a little different. There are 2 in Toronto, and one deals with youth and also first offender type of people, where you have all kinds of counseling programs all under one roof. So basically, they try to keep the offender out of the courts, try to give them a chance and hook them up to different programs to do with whether substance abuse or addiction. So I think things are moving slowly, but they are moving in terms of the specialized courts, and as I mentioned, provincially, at least the justice centers. And I know in other provinces they have not-for-profit organizations that are basically supported by the provincial governments. For example, Saskatchewan and Manitoba, where they have justice committees, where they have people dealing with offenders outside of the court. So it's sort of after the charge, but try to avoid them from going to court and going through the process and getting stigmatized, all that stuff that comes with a criminal record. So I think stuff is happening. It's just a matter of just the fact that it's sprinkled and it's slow going.
Mhm.
So,
Yeah, thanks, Devin. I mean, there's examples of this kind of thing, and they've been around forever. I mean, once upon a time, a long time ago, when I worked for the Chief Justice of the Family Court, diversion was a very big thing. Obviously, when it came to then juvenile delinquents, now offenders, and Gladue courts, where they are is obviously a diversionary tactic as well, to try to keep Indigenous offenders out of the jail to a great degree, although it's not a get out of jail free card by any means, but that's what it's there for. What I'm going to suggest is new business, which is item 6 on the agenda. I'm going to insert a new subsection C dealing with this, and we'll return to it later in the meeting. So Matthew, keep this the top of mind for you, because I'm going to come back to you on this when we get to that new part of the agenda. Okay, so we'll discuss it a little bit more as a function of new business. Okay, any other issues on the mandate letter for the Minister of Justice? Okay, I'll move to the one that was issued to Minister Mendocino, which is the Minister of Public Safety. Far less, actually, from a content point of view for the ministry, and that is appropriate because it's not quite as weighty as justice. But the mandate includes to the Minister of Public Safety to continue to work to keep our cities and communities safe from gun violence, and there's a number of subsets for the mandate that deals with that. To accelerate action to reform the RCMP by creating further oversight, to introduce legislation to create a review body, which again is oversight for the Canada Border Services Agency, to continue to work with First Nation partners to co-develop a legislative framework for First Nations policing. Most of you would know that there are already First Nations policing in various parts of the country. Already operational. There's a First Nations police force. Some First Nations have their own First Nations policing. Anishinaabe Police Services, when I was teaching in Algoma University, you had the Anishinaabe Police Services there for both, for essentially Garden River, the First Nation Reserve. So they actually policed 6 reserves. So so obviously this is a promulgation of more of that. Again, and we saw this in the justice letter, to investigate all forms of major financial crime. I don't know of any current issue that makes that such a priority these days. Usually a lot of these things, the mandate letters, are a function of issues that have come forward, and that they're going to be addressed. But this is one that's been repeated in both mandate letters, but it's there. Likewise, and this is along the same lines, to advance the National Cybersecurity Action Plan, to continue to combat systemic racism and discrimination in the criminal justice system, to advance reforms to the pardons program, and obviously that's an issue that we're dealing with already, and we'll get back to that, to address systemic barriers, promote reintegration, and ensure the system is fair and proportionate. Let's see, to continue advancing Canada's first ever National Action Plan on Post-Traumatic Stress Injuries. All right, and that's the last one I highlighted. Does anybody have any other issues in the mandate letter to public safety that they want to bring to our attention? Okay, all right, so let's move on then. Thanks everybody. All right. Other news and announcements. The only other news and announcements I have is with reference to the CCGA news and policy update that came out yesterday, I believe it was. So there's a couple issues in that I thought that we should touch on. This is put together by Howard. So he had a number of them highlighted. One of them that I think is worth mentioning that we're all familiar with is the agreement in principle reached for First Nations children, resolving the years of litigation regarding discriminatory underfunding of child welfare services. So this is the resolution, finally, of a long human rights case dealing with basically welfare for Indigenous children. So $40 billion now has been set aside in that regard. Half of it essentially to be paid out to children and families of the children, and the other half to put into place initiatives going forward to a great degree, essentially establish a new child welfare regime for Indigenous children, mostly on reserve. Anybody have any comments on this particular item? It's been in the news quite a bit. Okay, we're good. An action plan for decarceration. So this is actually came forward from the Canadian Bar Association. So this should tie in nicely with our new item 6C, dealing with alternatives to decarceration. So if you hadn't seen this, this was published January the 6th in the National. So it's the CBA's at their AGM called for immediate action to address the growingly severe human rights problem inside Canada's prisons. Specifically, the resolution says it's time to defund the CSC, calling on the federal government to immediately begin negotiations with Indigenous communities to draft an action plan to set up and fund well-resourced, preventative, community-based services and alternatives to incarceration of Indigenous peoples. So this is focused, again, it deals with systemic overrepresentation in prisons of Indigenous offenders, I think our line item in the new business is going to be broader decarceration overall, not just aimed at Indigenous offenders, but obviously because there's such an overrepresentation of Indigenous offenders, then that would be the first focus target for this kind of purpose. So that was in the CGA news items of yesterday. Anybody have anything to add to that? Or wait till we get to it? So we have that one, and then let's see. And the other one I just wanted to mention was that in the news policy announcement, it made reference to the Supreme Court has 3 cases coming before it in the current session or the new section dealing with challenging section 33.1 of the Criminal Code. That section states that a person who voluntarily consumes alcohol or other intoxicants to the extent that they lose conscious control of their actions and commit a crime of violence are still accountable for that crime. And for those of you who may recall when this came into effect, it was prior to the enactment of 33.1, it was a defense, in cases where somebody was so blindly drunk and or intoxicated by narcotics that they no longer had essentially the mens rea to commit the crime, that in fact it provided a defense. And so Parliament enacted 33.1 to remove that defense. And now what we have is this 3 cases coming back before the court trying to basically to challenge the constitutionality of that section, basically trying to put back into place the availability of the defense. Not much that we can do obviously about that, but we can certainly see what happens at the court, and then we can discuss it thereafter, because if the court strikes it down, it creates a very large area of a defense when people, and particularly domestic cases where a spouse will be intoxicated and be violent to the other spouse, and that defense is no longer there. But these cases deal with opening that defense back up again. Any thoughts, comments on that particular issue? No? Okay. All right, so those are the new items that I wanted to bring to your attention as a function of the newsletter. So there we go. Let's then move on to business arising, right, from our last meeting. So the first one deals with the committees, review of the committee activities. I'll go with the first one, which is Justice and Human Rights. So again, just as in last month, the only thing the committee has done is it's organized itself and created chairs and vice chairs. The chair of the Commons Justice and Human Rights Committee is Randeep Sarai. He's a Liberal from Surrey Central. So I'm not familiar with this particular member. I don't know whether he was newly elected in the last election or not, but he's now the chair. Nothing else has happened in this particular committee. So the committees will, right now we all know that Parliament is on its winter break, so it broke the second or third week in December, comes back on January 31st. So we'll have some committee activity for our next meeting in February, but no committee activity is going on right now. Rob, Public Safety and National Security, anything on that committee?
Yes, they had not a huge amount, but they did have 2 meetings, and one on December 14th, the other one on December 16th. The first meeting on December 14th was to decide who to invite to present evidence at future meetings regarding firearms and gangs. So they settled on or rather chose the RCMP and the CBSA and their unions. And they also decided to, or had a discussion about a previously presented report on systemic racism in policing in Canada. And that was adopted by the committee last May and presented to the House in June with a request for the government to respond to it. There must not have been a response because this committee decided to re-adopt, and they will represent and re-request a government response in this session. So that's that's underway, or been done as far as I can tell, as far as represent, or at least decision to represent. They did decide to readopt it and move it along. So then they also had a quick discussion on whether they want to get involved in the Huawei involvement in Canada's 5G network, but the committee didn't really agree on pursuing that with other priorities around sort of out there. So that was dropped. Then on December 16th, they decided to pursue the gun control discussion. So they commenced a study on gun control, illegal arms trafficking, and the increase in gun crimes committed by members of street gangs. That was in part response to an increase in gun crime and gun trafficking in around Montreal area, and also the the regulations under Bill C-71 were referred to the committee by the minister. So following some discussion with the minister, the CBSA president, Department of Public Safety, Emergency Preparedness Deputy Minister, and the RCMP Commissioner, and a few others who had joined them, the committee decided to instruct the chair to report the firearms regs back unamended. And they had at the end of it, they had another discussion with the chair about retabling that report I mentioned earlier, and that will be done. So not a lot, they just seem to be getting started, and but moving forward with a few things there.
Well,
that's it.
Yeah, thanks for that, Rob. Appreciate that. Do you recall who the chair of the Public Safety and National Security Committee is?
Yeah, I mentioned that last time, but I forget off the top of my head his name. But I think I have it still open. If you give me 1 second.
Sure.
Sorry, just doing a few clicks here. As a Liberal, Jim Carr.
Okay.
And Vice Chairs Raquel Dancho, Conservative, and Christina Michaud, Bloc Québécois.
Super. Thanks, Rob.
Thank you.
Okay, for the Senate committees, first up, Legal and Constitutional Affairs. Brendan, anything to report?
Not much. There was one meeting, so rather than sort of repeat what Sean and I discussed last meeting, there was one meeting right after our December meeting. It was just to discuss the changing of an electoral district. So my understanding, that's not really of interest to us. The one thing that is, I believe, would be of interest to us was that the committee discussed clauses 1 to 5 in Bill C-3, which was the bill which essentially added as a criminal infraction to impede or assault or in any way healthcare workers. It was that bill there. So as we know, that bill received royal assent shortly thereafter. So I think I'll just leave my comments there. There was no changes made.
Brendan, thank you. Okay, so we do not yet have a volunteer for the Human Rights Committee in the Senate, so I'll follow up on that. Again, they've had their organizational meeting. The chair is a senator from Toronto. Her name is Selma Atalashan. She's conservative. She identifies as conservative, so she's the chair. They've had one meeting to review a bill in committee. It's Bill S-211. It's an act to fight against forced labor and child labor in supply chains and to amend the Customs Tariff Act. So what it basically says is that it imposes an obligation on certain government institutions and private sector entities to report on the measures taken to prevent and reduce the risk that forced labor or child labor is used by them in their supply chains. So we don't even have that on our list of bills relating to justice issues, but it is part of the purview of this particular committee. Okay, guys, thank you. The next item is the Criminal Cases Review Commission report. We talked about this at length last day. This is the committee that I'm part of on behalf of both the CCGA and my other work. Nothing has happened on that. The report has been submitted to the Minister of Justice. He's reviewing it. It's been published. The actual all that's been published actually is the executive summary so far and the highlights of the report. The full report has not yet been made public, so we'll watch to see when that happens. But at this stage of the game, it's still in the works with the Minister of Justice. And as I mentioned earlier, it's part of the minister's mandate to follow through with this report, because it is a mandated issue by the Prime Minister to in fact create what is going to be called a Miscarriages of Justice Commission for the purposes of identifying and providing relief to those who allege they've been wrongly convicted and for the most part incarcerated. So we'll come back to that. Item 5C, the CSC consultations on SIUs, the follow-up. I just give you all simply a link to a Globe and Mail article dealing with Howard Sapers, who has been appointed as the chair, and this was actually last summer. He's appointed the chair of this particular advisory panel. And just following up on a comment that Matthew made at the last meeting, Tony Dube is no longer the chair, but he still is on the panel. He's continuing as a member. So he hasn't left this work, although he's not running the show for the most part. Okay, item number 5D, confinement reform. This is dealing with Andrea and what she's doing in the Yukon. And Andrea is preparing a piece for the Justice Report. So she and I have talked about this in the last few days. And so there's nothing to, do you have anything to add to that, Andrea?
Nope, nothing.
Okay, good enough. So we're looking forward to that. So Andrea knows what to do as far as getting it before the Justice Report. So we look forward to reading that. So thank you for that work. The next item E, the John Howard, the initiative, the NAACJ initiative. It's simply a waiting brief. Nothing has happened on that since the last day. So I don't presume Irving has anything to add to it.
Not more than I said before.
No, that's cool. Thank you. F, the draft brief on rural crime. So that's become a waiting brief for us as well. Brendan is on that, as likewise Peter is with respect to the prospective institution of the Alberta Provincial Police. I presume there's nothing happening on that. Essentially, it's a waiting brief. We're waiting to see if it's going to be reintroduced. It was a new members bill in the last Parliament, and we're waiting to see if it's coming forward again. And once it does, then it will move into the bill section of our agenda as opposed to a waiting brief. Anything to add to that, Brendan?
Not to date. I haven't seen any movement on it.
Okay,
yet.
Super. Thank you. The next item is the invitation that we have to participate on a consultation regarding facial recognition. Peter is on that for us. He received an email from that group after our last meeting on December 21st, basically indicating that we missed the actual first online meeting, which was December the 7th. But Peter's been invited to prepare his comments on behalf of the PRC to this group. So Peter couldn't attend today, but I'm sure he'll prepare the comments and I'll circulate them once we have them. So that's nothing is happening on that other than waiting for Peter to further participate on it. The next item, so we'll have a bit of discussion on this one. This is whether we PRC and now the board CCGA whether we are joining the Fresh Start Coalition. This is the coalition of 60 justice-minded groups across the country with respect to the implementation of a spent conviction regime, which we've talked about at length at this point, to replace the record suspension program now in place at the federal level for those seeking what was used to be a pardon and hopefully reverts to a pardon. So we had it with Irving, who is going to take it back to the board. I know there's been some correspondence on it. I've seen that. So Irving, where do we stand on the CCGA's position regarding this coalition?
Well, we've heard back from each of the board members, and essentially the members voted to maintain the position that was adopted back, I think it was February, on S208. Their issue was, again, the primarily, I mean, there are different viewpoints, but primarily it was the lack of maybe explicit exception for child sex offenders. So that's where that stands.
So and this is obviously has to come from the board, but is the position that that we become part of the coalition with that caveat, or that we just stand by the board's previous position and leave it at that?
I think it's basically status quo.
Okay, so there's then, because they're waiting to hear back from us. I simply tell them that we're not joining the coalition at this point, but we have a position that's been made known with the prior iteration of the bill S208. Is that
Yeah, and I think if you're going to respond in writing, obviously, I would suggest you attach. Do you have the brief on S208?
I've already given it to them, actually.
Okay,
Yeah.
well, so I mean, that's our position, obviously, and for the record, and for anybody who's not aware, we've been fighting the changes that the Harper government brought in basically abandoning the pardon system or bringing the suspension system with all the delays and the costs and so forth and so on. We've been fighting that since about 2006 or something of that nature. So that's not new to us. We've always been supportive of bringing back or having a pardon system that was like 98% effective in the past. So that's always been re-emphasized. I think there is the board is prepared to go further, and S208 takes us further than it was prior to the abolition of the old pardon system or the severe modifications of it. But it's the issue of almost no exceptions. Now I know there's some reference to folks applying for in the vulnerable sector. They can be reviewed and so forth and so on. But I think that has to be front and center. And frankly, I can't see this government buying in to the coalition's perspective.
Well, you be right, Irving. I mean, there was an editorial in the Toronto Star yesterday. I didn't include this in the materials.
Yeah.
But the editorial was very much along those lines, that the premise is sound. But having said that, there is that exception that the records would still be available if a vulnerable sector check is required. But the editorial also went so far as to say that it would not be inappropriate to consider carving out an exception where sexual offenses are at issue, right? Which the coalition doesn't currently do.
Interesting. I didn't see that article. That's interesting, Miles. If we go back to what Harper did, why, if you recall, it was simply a newspaper article about James, the fellow who was a trainer or whatever, he was a cleaner, I don't recall, an assistant at Maple Leaf Gardens, and he'd been involved, I think, with a number of hockey players, and he'd been basically pardoned. You recall? He didn't do anything wrong.
It was James, and he was a junior. He was a junior coach in
whatever he was.
Yeah, and he abused Sheldon Kennedy, and I've forgotten.
I don't know about Theo Fleury was there. Also,
Theo Fleury as well. Exactly.
Also, another one of the victims. But when the only what happened was it became public that he got pardoned, and then the government, quickly tried to close down anything that was anything open to a sex offender, a past sex offender, and so on. So I think you got to be I didn't read the Star article, but the way you're describing it, we have to be, if we really want to make some impact on it, I think we have to maintain the position we have in 208, and I think we have to be cognizant of the ability of politicians to make decisions that could really, really bite them in the backside, right?
I get that. I also included, for the purposes of today's meeting, a clip from I'm not sure if it was a Star or not, that the one thing that this government has done, and it did it effective January the 1st, is it reduced the fee. It returned the fee back to its original $50, which is the fee that it was before Harper amended it in 2010. So
Right.
they've done that. But as I mentioned earlier in the mandate letter still has this issue as something that the Minister of Justice, or actually this is the Minister of Public Safety's purview, has to look after. So again, they're going to do something more than what they've already done. What it involves, we don't know. You recall that before the last Parliament was dissolved, there was a bill put forward, another bill, so a fifth iteration of this to return to the pardon system to reduce the waiting times. That's a big issue, right? We're going to go back to go back to 3 years
2 and
for
5.
conviction, 5 for indictable.
Yeah.
And they've already taken care of the fee issue. So I think Irving's absolutely correct that the one issue that I think the government will tread very carefully about is that nobody, under very few circumstances, Kim Pate disagrees with this position, but most people do not support the issue of past sexual crimes and convictions being eradicated as a function of a spent conviction regime. That there's got to be some control over that going forward. So that is pretty much the issue that it's coalescing around. That when it goes forward, we'll see what the federal government position it takes. But I think Irving
on the matter, Miles, if I could interrupt,
Absolutely.
pardon me. This is actually a question for Irving. Did the board specifically address the question of joining the coalition with a caveat, or was that specifically presented to the board?
Not necessarily. I mean, it was raised by 1 or 2 members. I can't recall, but at the end of the day, it is what it is. The decision was not to join the coalition. And we can cut it, slice it and dice it, I suppose, and go back and say, how do we do this and that? But I think that would be, the way I understand it, Miles responding back to the coalition can highlight that issue. And if they want to come back and modify their document, if that's what it's going to be, then obviously I think it would make it easier for board members to agree to that.
Well, I'm of the view that the PRC should send up another resolution to the board that we join the Fresh Start Coalition with a caveat, and I'd ask for a second on that motion.
I'm not sure what that means exactly. You have, I don't know how many organizations that are part of the coalition, and we're going to say, we're going to join, but we want this sort of, I don't know, what in brackets? I don't know. I'm having difficulty sort of conceiving of how it would look after. Do you know what I mean? On behalf of, on the part of the coalition itself. Like this organization agrees to this, but not to that. And that it's not a coalition anymore if you have all kinds of provisos, I presume.
Well, let me share with you a criminological fact, which the public often doesn't know, but that sex offenders have a relatively low recidivism rate vis-a-vis non-sex offenders, particularly robbers or anybody with a alcohol drug dependency. And so we get into this fear and loathing campaign against sex offenders when they are, in many cases, a very manageable group for community penalties. So I'm just wondering if there's no second on my motion, I will take it on the chin.
Well, just wait. We're still discussing it, Matthew, so don't give up yet. And your position, you're absolutely right about the recidivism rate of sexual offenders. It's low. Kim Pate, that's the position she takes as well. Andrea, you put your hand up a couple of times.
Yeah, I've been fortunate enough to see some of the correspondence between those of us who are on the board. And one of the things I wanted to bring back to this meeting was really a conversation around, is there merit in actually going back to the coalition to ask them about some of the issues that the board members were raising as concerns? Because there were a number of board members that were supportive with a number of, concerns around X, Y, and Z, only because the coalition hadn't flushed that out yet. And for me, I think there's merit in going forward and actually touching base with the coalition and finding out if there's more meat on the bones to what they were, to what they're proposing, before making a determination as to whether or not we're actually going to join or not.
All right, I certainly have no problem with that. I mean, so now we need the PRC to direct me to do this. But I mean, so what you're saying is I could correspond with my contact at the coalition and basically say that we'd like to know what the coalition's position, is coalescing around that particular issue. Is that the thought?
Yeah. I think that, and I don't want to interject there, but I think that would make sense. There was a degree of vagueness in the coalition's statement, right?
Well, what I would suggest is I go back to the coalition, and again, this is with the approval of the PRC, but I'll go back to the coalition. I'll make reference back to S208, which actually has our proviso, on the issue. And say this is something that we really need to have more elucidation on before we can actually put this before the board to approve joining or not. That makes sense?
Yeah, but to be honest, I think that vagueness provides us with an opportunity to help shape it, given the notoriety of this particular association. And so I know the two primary signatories on that coalition are probably very open to feedback based on the work that I've done with them in the past.
All right. So then someone please move and second that particular item, and I'll move forward with it. So I need a mover.
I'm happy to move that as stated.
Okay, and Andrea, I think you could be a seconder. Thank you. All those in favor? Carried. Thank you. Okay, I will do that. Thanks very much, guys. Okay, that brings us to new business, item 6. The first one is a political party platform analysis. I've attached that for everybody's review. It's a 15-odd page report. This was prepared by students that are hired by Howard through one of the programs that he handles. And what it basically is, and I don't intend to go through it all in detail unless you'd like to, but it simply sets out what the platforms of the political parties were in the last election in the last fall. What the issues are that they put forward for purposes of being elected. And I guess the real benefit of this kind of document is comparatively speaking, looking back on it, 2 years from now, when we go to the polls again in a minority situation, how well did the parties, obviously the Liberal Party, live up to what it proposed to do, as a function of being elected last time around. And a lot of it, to be fair, there are parts of the platforms already that we've already seen in the initial return to the new parliament. But there hasn't been a lot of parliamentary activity yet. It convened rather late in the fall. So it's really an informational document for our purposes at this stage of the game, and to look back on. So kudos to Howard for having it prepared by his students. It's interesting. Clearly, it's something that is there to hold up to the light of day in October of 2024, or whenever it's going to be next time we really care about what the platforms are. Does anybody have any other comments about this particular document that I've attached to the agenda? Okay, good, thank you. Next item, this is a new one. Sean sent this to me this in the last week. Now Sean's not here, so we can certainly come back to it next meeting when he returns. He attended the annual conference of the Canadian Institute for the Administration of Justice, and it had a report that was generated. So I've attached the report for your review, dealing with Indigenous peoples in the law. So it's an interesting report. I propose that we put this over to next month when Sean can speak to it. Sean actually attended the meeting virtually, I presume, and he certainly was he thought it was of significant enough interest for us to take a look at it. So I propose that we just put this over for next meeting. Unless anybody-
Miles,
Yes, Matthew.
if I can ask Irving a question. Irving,
Yeah.
didn't CCJA publish an old study titled Indigenous People and the Law?
Yes, they did.
Was that in the 80s or 70s?
Before my time. It was a very popular publication, by the way. There may or may not, well, there may be a copy or two still in the office. But
Well,
it's not in digital form though, right? It's in hard
I
copy.
think historically, if we're going to revisit this issue, we ought to bring forward our historical history on this.
Yeah, yeah. I don't recall who did it. Do you, Matt?
Not a clue, but I remember when I wrote the history of the
Yes,
first 75 years, I came
Right.
across it.
right, right. Yeah, last time I was in the office, I saw copies somewhere still, probably on my bookshelf, but there may be one or two copies lying around. Well, I guess what we could do is whoever becomes the pen holder for the initiative, we'll get them a copy. There aren't many, but there should be one or two or three in the office somewhere.
All right, guys, that's super. So I'll just make a note on this agenda item. I guess I'll put that in brackets that there is a prior CCGA report floating around. Is it PRC or board report?
It was commissioned by the board, presumably.
Okay,
And as Matt is saying, it must go back, 30 years at least.
all right, goodness. Okay, all right, well, I'll make note of that in the, on this agenda item.
Yeah,
Okay, next, this is our last business arising item, or is actually new item that Matt brought up earlier, dealing with alternatives to custody measures and what have you. So Matthew, what do you propose? How are we going to frame this on our agenda?
Well, the idea was to respond to the mandate letters by putting forward a 1 or 2 page letter on behalf of the association, pointing out our longstanding policy recommendation to the governments. This is not only a longstanding position, it actually, one of the reasons that the association was formed in the very beginning was this very issue of incarceration alternatives. So it's fairly historic for CCJA. And what the purpose would be to highlight what we perceive to be still a very pressing and significant issue that ought to be considered by both ministers. Anyway, that's the pitch. I don't know if my colleagues agree, but Kyle and I probably would be willing to draft up something, and then Irving will rewrite it. And
you know, if I could take a second, there are a lot of threads to that fabric, right? And we've done a lot of odds and well, I wouldn't call them odds and sods, but become different letters and briefs that are related to that. As late as say a year and a half ago, at the beginnings of COVID, Howard and I wrote to ministers. That letter is probably on our website. Talking about, we wrote to the Commissioner of Corrections, talking about how we should take this opportunity to de-incarcerate, essentially, lower the population of offenders, looking at, first and foremost, those who are, close to their release dates, and secondly, those 25% of the federal population that are aged, right? It's got to be at least 25, and it's growing, obviously, because life sentences never end and so forth, and they're not released very, very early in their 25-year minimum or whatever it happens to be. So we can probably, if you want to start that with Kyle, Matt, I can do some research work and find some, as I said, some of those threads that you can embroider into or we can embroider into the final article.
All right, guys.
Well, that's a capital idea in my view, but I hope that my colleagues on the PRC would endorse that.
Well, I can't, I don't want to speak for all your colleagues, but the point is, there is some common sense potentials, not solutions, but there's some assistance that's possible if government and the bureaucrats were to look at in a much more micro way at what numbers or what kinds of individuals could be released earlier than now in order to reduce the population. We know that with COVID, the provincial populations have dropped. We assume that bail is given more frequently. I don't know. Andrea saying no. But in any case, we know the provincial population numbers did decline early on in COVID. I don't know what they are right now.
They've actually increased, that they're going back up, unfortunately. And they
So
have been since like July.
They're catching up. But the message, I mean, the lesson to be learned is that hell didn't break loose all over the country because the numbers went down. So why are they going up now? So they brought back, you know, the old kind of processes and that they used before, which didn't appear to be all that necessary maybe a year and a half ago. I'm just speculating, Brendan, but you know what I mean?
Yeah.
Right, guys,
Actually, I should, my current, like, I'm actually writing a paper on that right now.
Well, there you go.
So this is a pretty substantive issue. So I'll frame it and put it into the agenda, and then we'll start putting meat on the bones as we go forward. So thank you, Matthew and Irving, everybody for that. It's exciting. Okay, and it's almost 1 o'clock, so I apologize. We're going to go over just a little bit, but not too much, because if you turn now to the criminal justice bills before the Commons and the Senate, I mean, very, very little has happened to those bills that we're following. There's some new bills that were introduced after our last meeting in December. But I can tell you that if you look at what I've given you from a list, Bill C3, we don't have to revisit any further. It's law. This is the one dealing with it being an offense to impede somebody from obtaining health services. So that's that had royal assent on December 17th, so after our last meeting. So that's now in place. With respect to Bill C5 to amend the Criminal Code and Controlled Drugs and Substances Act, which is the sentencing reform dealing with mandatory minimums, which we referenced in the mandate letters. It's in second reading, and that's in process. So there's nothing to report other than we'll have committee work on that, I would think, next meeting. The act to amend the Judges Act. This is newly introduced since our last meeting. This is actually replaces the Bill S3 that was in the Senate. So that's now been taken off the order paper in the Senate. It's now been introduced into the Commons. It had first reading on December the 16th. And this is, and I didn't realize this was a real issue, like a significant issue, but the government seemed to think so. They want to revamp how to police essentially the conduct of federally appointed judges. So, you know, there's been a handful of cases in the last 10 years dealing with inappropriate comments or activities of judges, and they tend to be removed by the Canadian, the Central Committee for
Judicial Council. Yeah.
But now they want to have, I think, a separate oversight process. So that's going forward. So that's new. Private members bill. So those are the only two public bills in the Commons that we have on our agenda. Private member bill C202. There's been no change since last meeting, or C216 or C220. So those three private bills, there's been no change. So we'll see what happens at our next meeting. In the Senate, there are no Senate government bills in place, because the only one that we had was the one I just mentioned, the one to amend the Judges Act, and it's now been rescinded on the order paper. Private member bills, we have no change to S206. Bill S212, which is the private members bill that ties into the Fresh Start Coalition. It's in second reading and will be into committee, so we'll see what happens there. S213, this deals with independence of the judiciary. This was something that Olivia was looking after, but in fact didn't have time to do it. And Francois was preparing a brief, and Francois has left us. So Irving was going to check its whereabouts, but now we have to check Irving's whereabouts. because he's now left the meeting. So I'll leave that as it is. S224, nothing, there's no change. S230, there's no change. 231, no change. And likewise, S232, no change. So all of those, we all have the background for them at our last meeting, and it's now obviously in the agenda, but there's been no change in any of those, and that's because committees have adjourned until the end of the month. All right, everybody, that's it. So there we go. So not too bad time-wise. Any other comments or concerns for the PRC before we adjourn for January?
Move to adjourn.
Move to adjourn. All those in favor? Thank you very much. Happy New Year, everybody. Thank you very much for attending, and we'll see you in February. I think our next meeting is, just so I can get it in front of you, February the 8th. All right, guys.
Thank
Have a good
you.
day.
Take care, everyone.
Take care.